Broadcasting, go.
Good afternoon, everyone. I'm Keith Gillis, former president of NAIFA, and I'm happy to moderate this version of the NAIFA webinar series called Pandemic PPP and Policy. We have three outstanding speakers for our program this afternoon. Diane Boyle, who is our Senior Vice President of Government Relations, Bob Keebler, who is with Keebler and Associates, and Julie Kamer, who is an expert on labor law. So with that, I would like to review the disclaimer with you and also to ask you, if you have any questions, to please put them in the Q&A section of the webinar. And with that, I will turn it over to my friend, Diane Boyle.
Great, thanks, Keith. I'm going to do a little bit of stage setting for folks, and then we'll get to Bob and Julie, who will really give you the meat of the program. If you look at sort of how we got here, the Congress took action in several phases. The first phase was really initial support on vaccine development, looking at the medical side. Phase two, and this is where Julie's going to spend a lot of her time, really got into that expansion of the Families First Coronavirus Response Act, and that did the expansion on FEMA and paid leave, and she'll talk about that in detail. All of this happened very quickly. Phase three also enacted in March. Phase one, phase two, phase three, all in March. Congress came together, worked together to pass these bills. Phase three, and that's probably why a number of you, and I looked at the surveys, didn't realize that there was an expansion of the FMLA. And that's because you were probably focused on phase three, which was the CARES Act. That's where we saw the PPP, which Bob's going to spend a bunch of his time talking about and going through details, how it's forgiven. And then we had what we like to call phase 3B, because it really wasn't another phase. It was really some fixes to that Paycheck Protection Program. And so it made some modifications there. It extended the loan application. And that was done in April and then in July. And what's key as we move into phase four is that they're expiring provisions. So if you look at July 31st is when the payments to the enhanced unemployment benefits end, and August 8th is the date which the loan applications were extended to, and that will expire. So Congress really needs to act before those provisions expire. And so they're coming together today. Let's go ahead and go to the next slide, and we can talk about what's coming down the pike. So this morning, the Republicans met at the White House to talk about their version of phase four. Democrats were meeting at 3:15 to talk about what's in their package. This gives you a broad overview of where the two parties are sort of coming from. The challenges here is that the Democrats passed the HEROES Act, and the HEROES Act comes with a price tag of $3 trillion. The Republicans have said, we're looking at a package that's going to be about $1 trillion. So you would think $2 trillion amongst friends really isn't that much, and they could come together very quickly. However, that's proven to be a little difficult. So it's going to take a while to figure out how do you come to the right dollar amount, the right package, the right provisions when we're in an election year. So those are the challenges that we sort of face as we move to phase four. NAIFA has a number of initiatives, just as we did when we went through phase three, where we were pushing for retirement benefits and the loan provisions. We're still looking at enhanced retirement provisions, some life insurance tax changes, some health changes that would all be part of phase four. It's going to depend on how big that tax title is, whether our encouraged positions actually get included or not. Let's go ahead and go to the next slide. So these deadlines aren't really ours, but it plays into how quickly that package can move. If Congress doesn't act before they go off on August recess, they're going to come back, and there are a number of legislative deadlines that they have to hit, including funding the government. So all of this factors into how quickly can they come together, what do they need to prioritize, are there other vehicles that maybe they can wait and tie a bigger package together, do they do a small one before the August recess and then come back and do a larger package? Do they push off doing phase 4 until after the August recess? Some of the things that they're looking at too. We go ahead and go to the next slide. There's also potential add-ons, if you will. So these are initiatives. The most recent was police reform. As we saw sort of the unrest of the country, there's a push for, is there police reform? So could you take police reform and tack it on to one of those must-pass pieces of the legislation that we just covered? Other issues that they're looking at, climate change is a high Democratic priority and maybe something that they try to push to be included on that legislation. Surprise billing is another issue, and drug pricing. So all of these things potentially could be added on to different packages depending on what moves, and that's what we're watching really closely. Go to the next slide. This is the real challenge. If you look at the congressional calendar, there isn't much time to get all of this done. What you want to watch is the purple blocks. The purple blocks are when both chambers are in session, and that's when they can really negotiate a package and pass legislation. So you notice August recess, there's very little time aside from a week where the Senate is in on their own. Nothing in August. Then you come back in September. We have that long list of deadlines that Congress has to enact. So they may need to shift their focus if they don't get that package done before September, because then they're looking to fund the government. And that, as you know, always proves to be really fun. Then you have a couple of days in October, November elections. Depending on how the elections go, you have a lame duck session to come back to, and that changes the dynamics. So it's all very fluid at this point. But what we're going to do now, just wanted to sort of lay out how we got to where we are, what we see coming down the pike. And in the meantime, we'll hear from Bob and Julie, who can tell you in the real world, because I'm fully aware that working with Congress is nothing like your day-to-day lives in the real world, and how once they act and you have to take those provisions, those new laws, and enact them, it becomes very different. So it's my pleasure at this point to turn things over to Bob Keebler, who's going to run through some of the payroll protection program, basic information, and how you can actually pull together the information that you need to make sure that you're able to have that program and your loans forgiven. So Bob, on to you.
Thank you, Diane, and it's an honor to be here. And hopefully I'll be able to bring a little bit of insight into where we are right now. Now, in the bill that's coming up, there will be likely a second round of PPP, but it's going to be very targeted, perhaps the way it should have been in the first place, because all of us represent businesses that are really hurting, and some of us represent businesses that are actually doing better than they did before, and yet they were still eligible for PPP and have a bit of a forgiveness there, and that will enhance their wealth, maybe on a little bit unfair. Now, if we look up at the next page, page 2 of the materials, we start talking about loan maturity, okay? And now we have a 5-year minimum term. This was in a bill that passed on June 5th, 2020. So we originally had a bill kind of towards the end of March, then this other bill came up. The thing about this second bill is we've gone from 8 weeks to 24 weeks. That's a big deal. They also changed the 75% payroll tax or payroll test down to 60%. What this means, if I want to have 100,000 forgiven, at least 60,000 of that needs to be from payroll. So you have to be very, very careful that you're meeting this test. Now, full-time equivalents, again, if you rehire people by 12/31, they're going to count in the equation. We'll show you where that is. And if the employer can document the inability to rehire or to hire similarly qualified individuals, the new law gives that particular employee a pass on that issue. Now, borrowers can also defer half of their Social Security benefits. So, and what does that mean? What happened under prior law is if you were taking PPP, once you had your forgiveness, you were no longer eligible for deferral of half your Social Security. Now that's changed. So I can not only get PPP, but I can also defer half of my Social Security taxes of the employer's part. And that is going to be a big thing if you're over $2 million, because you have to prove that necessity issue. Remember how over 2 million, you still have to show you have necessity. Under 2 million, they waive that requirement. So if you're over 2 million, I think you really have to take a good look at deferring half of your Social Security taxes. Let's jump up to the next slide, please. Now, the CARES Act was the original bill, and it provided that a taxpayer who participated in PPP was ineligible. Now we've jumped to the new bill where you can actually participate in both programs. That's a great thing. The applicable date, when you're paying this back, you pay half of it in December of 21 and the other half in December of 22. Now, interest rates are very low right now, but for the right person, this gives you a little bit extra cash flow. But keep in mind, this loan is not going to go away. This is going to be due, and we have to be very careful with that. If you look at the next slide. So what we're looking at here is we can go all the way to 12/31. And when we get into forgiveness, this is a real blessing because you're going to be able to just use payroll and not goof around with how do you account for rents or rental expenses? How do you account for various expenses and all the different accounting methods you could use? And there was just a lot of debate on that. Good, solid intellectual debate, but it was ridiculous that Congress did not have the opportunity to spell that out a little bit crisper. I think that problem has basically gone away. Now, generally, you have to have less than 500 employees. That didn't change, but what's going on here, more importantly, is there are exceptions to the 500 employee rules. I have a couple of people that are in those exceptions, and you can still get PPP. So if somebody on the second round has 6 or 7 or 800 employees, don't just give up. Try to see if they qualify under one of the other exceptions. If we look at the next page, please. On eligibility details, again, self-employed individuals and independent contractors are still eligible. There's some pretty big restrictions, but you can still get some help. That's what I want to really focus on, is you still can get some help. And if we look at the next slide, now let's just slow down a little bit and go through this. So what does payroll include? To have forgiveness, you have to have payroll. That's one of the elements. And that's salary, commissions, tips, paid leave, healthcare payments, and more importantly, retirement benefit payments. So that's all in that mix. Now, I submit to you, if you go with the 24 weeks, you are not going to have to worry about healthcare or retirement. A lot of issues on how we would handle defined benefit, defined contribution plans. Most of those things have gone away under the new bill. Now, payroll costs do not include, this is kind of critical, they do not include people that are making over 100,000. If somebody's making 160,000, only the first 100,000 of wages would count. Qualified sick leave wages where you're taking a credit, or qualified family leave wages where you're taking a credit. And we may talk about that a little bit. Julie may touch on that. Those individuals are going to, those particular wages are not going to be eligible for PPP forgiveness. You can't get a credit and have forgiveness. Now, if you look up at the next page. So here we go. When we tried to take our loans out originally, you took your payroll, you multiplied that by 2.5. It was really a piece of cake. And the government was very smart when they put this together. A lot of thought went into it because they allowed for exceptions for seasonal employers, those with outstanding loans. They also looked at new businesses. If we look up at the next page. Now, once the money's in your bank account, what can you use it for? You can use it for payroll costs. You can use it for health care benefits. Employee salaries, wages, commissions, those all count. payment of any interest on a mortgage obligation, rent, utilities, interest on any debt obligations. These things all count when we're looking at what can be forgiven. But remember, 60% is going to have to be in what category? We talked about this a moment ago. It's going to have to be in payroll. So we need to be very cognizant of that. Let's jump up to the next slide, please. Now, unlike most SBA loans, there's no requirement that you have to be able to obtain credit anywhere else. That hasn't changed. Interesting enough, the loans are non-recourse. And that's something that's going to give the accountants great trouble when it comes to tax season, because how are you going to get basis? And there's no personal guarantee required, and there's absolutely no collateral required. And there's a little bit of inconsistency in the legislation. Nobody's really too worried about that. If we look at the next slide, please. Now, the one thing that's out there that didn't go away is the need for a certification. You have to certify in good faith, okay? You're going to have to certify in good faith that you needed this money, the money was necessary. Now, that requirement is waived if you're over 2 million. If you're under 2 million, they're going to waive that requirement. If you're over 2 million, before somebody submits, they really need to line up legal counsel and make sure that they feel they can defend what's called a necessity challenge. There's actually be very few people in this situation, but there will be some. Now, why did you, remember, we did this in the first place as a nation because we were trying to keep businesses in place. In other words, keep the band together, keep those 12 people that make a restaurant work together, because once they scatter to the four corners of the earth, it's going to take a long time to rebuild those teams. Congress recognized the necessity of allowing employers to continue to pay people. And that's what we're up against right now, is what are we going to do in the next round of PPP? But if you had to certify that the funds be used to retain workers, maintain payroll, and make lease payments and make utility payments. So that was what that's about. If you have somebody that has to do that, again, line up legal counsel before you submit that application. Let's go up to the next page, please. Now, what does necessity mean? This goes all the way back to Supreme Court cases that are over 100 years old. And necessity is not as strict as you think. And that's what you have to look for. I did a program with Marty Shakeman on some of this, and we kind of got into the very nitpicky definitions. And unfortunately, fortunately, maybe I should say, the Treasury eliminated anyone under 2 million. This is not your issue anymore. But if you're over 2 million, you could still have this necessity challenge. So we want to be very, very careful on this. Let's jump up one more page. Now, the remaining balance after forgiveness. If you borrowed $1 and we forgave 80 cents, you have another 20 cents that's now going to be a loan, very low interest, and you're going to be paying that back over a period of time. Looks like that could be as long as 10 years, okay? So that could be as long as 10 years. This is guaranteed by the SBA. That's why the banks could do these loans so quickly. One more page, please. So the general terms, Congress said not to exceed 4%. SBA said 1% loan. Deferment, Congress 6 to 12 months. SBA said 6 months. And the term of the loan, we're now at a 5-year rule under the Flexibility Act. So you can kind of see where we're going with all this. That Flexibility Act made things a lot simpler. Next page, please. Now, this disaster loan overlap. Where we are on this is there's a little, if you have somebody with both a PPP loan and a disaster overlap, I think you should study that. Take a good, hard look at that and try to figure out how they work together. In general, you're going to reduce your forgiveness by the amount of your economic injury disaster loan. That's kind of the heart of this, okay? But you're not barred from participating in both programs. That's the very important thing for all of us to keep in mind. Now let's talk about loan terms. Depends when you took out the loan, but the new round of loans will have a 5-year maturity. What we're going to have after the next bill passes Congress, though, you're actually going to be, you could have different clients on 3 different loan programs, which is going to add to the confusion. So we're going to have to try to keep that straight. On the term loan side, we really want to look at term loans made before June 5th, have a 2-year term. However, that can be extended to 5 years by mutual agreement. Loans made after June 5th, 2020 are all going to have a 5-year maturity. So we're back to 5 years, which at 1% isn't as painful as it looks. Now, we do have to be careful though. Remember, these are non-recourse loans, okay? So these are non-recourse loans. Go up to the next page, please. Again, be careful that you submit on time. If you don't submit your application on time, you're going to lose the possibility of forgiveness and you're going to have to start making payments. So, you know, it's a big country. Somebody is not going to submit on time. Just be very careful that that is not someone you're representing. So make sure that these things are double and triple ticklered. Okay, one more page, please. Now, what can be forgiven? So a principal amount is going to be forgiven based on your payroll, your mortgage interest, your rent, your utilities. All these things are going to come into play. We're not sure exactly what the definition of utilities would be. Payroll, though, is pretty black and white. And by using 24 weeks of payroll, that's easy to define. There's no fight about what retirement plan benefits you can include, how do you compute health insurance, none of that. It's all very, very straightforward. I do want to think about rent though, but most people, if you just run 24 weeks of payroll, you're going to get to 100% forgiveness. And that's really what you want. It's a little, this could be a little discriminatory for people on the coasts because rent is so high compared to payroll costs. And that's something that people are going to struggle with. Again, the 24 weeks will help with that. Okay, let's go up one more slide, please. Now, under the CARES Act, we originally had an 8-week program, and hardly anyone was going to meet forgiveness within 8 weeks. And that's because we were actually starting out with about 10 or 11 weeks of a loan, and then the payroll for a loan, and then you had to come up with enough to offset that in 8 weeks. So it was virtually impossible. And now that we're at 24 weeks, it's easy because you only borrowed 8 weeks or 10 weeks of payroll, and now you have 24 weeks to generate payroll to forgive that. Now, the important thing going forward is to really remember we want to focus in on getting the payroll in there so we can get that forgiven. That's really the important thing. Now, you can elect to use the 8 years for loans before June 5th, but you must use but you have to use 24 weeks for periods after June 5th. It's not entirely clear what happens if you file early. Let's go up to the next slide, please. Now, if there are 3 ways the government can punish you. If you didn't bring back people, you're going to lose some of your forgiveness. If you cut salaries too much, you're going to lose some of your forgiveness. And if you didn't have 60% of your covered expenses in the payroll category, you're going to lose some of your forgiveness. So this all becomes very, very important. What we're going to try to do most of all is fall within these rules. We're going to be very diligent on this. And what I want to see, at least for my clients, is an attempt to get through the forgiveness using just payroll. Now you can measure this over 2 periods of time. We can look at the 8-week covered period or the 24-week period. Those are going to be the things we compare. That is for the numerator of this equation. The denominator, though, is going to be based on either last year, 2019, like in this equation in front of you, or it's going to be predicated upon, and we'll go up one more slide, basically this period from January 1st through February 29th. And you do have a choice of which period you're going to use. And if we look at the next slide, this gets a little harder. Now, what if you can't, so we'll go up to the Paycheck Protection Program here. And basically, these employee reduction tests can be cured if payroll is restored. So all of these, the first 2 tests, the whole full-time equivalent test and the salary test can be fixed. Okay, those can be fixed if you fall into the right situation. All that can be fixed if you bring people back or if you restore their salaries. Now, there is quite a bit of freakonomics to this, because you see, if you have 60% payroll and 40% rent and you get 100% forgiveness, some of your rent is also going to be forgiven. But if you can't meet these restoration tests, you're not going to have that rent forgiven. So we've seen with clients where by bringing an employee back and paying them $1, we're going to get more than $1 of forgiveness. That's the math. And it's going to be very important for us to understand that when you're counseling people on whether they should bring their employees back. Remember, you just have to bring people back by 12/31. And this is terrible. This is absolutely terrible, because a truly evil person could bring somebody back right at the end of December. I don't think there's anything in the legislation that would prevent you from dismissing them in early January. And that's just not right, but it's where we are right now. Some of that perhaps is going to be cleaned up in this next bill. Okay, so again, that's kind of the big picture. Let's go up to the next test, and we'll talk about this salary test. Now, again, if you if you reduce salaries, but you restore everyone, what's going to happen very simply is you'll be back in a good spot where you're going to get 100% forgiveness. Now, if you have employees that earn more than $100,000, you cut their salaries, the government doesn't care about that. They care about the salaries you cut for folks who are making under $100,000 a year. Now, if we go up one more slide, and we're getting close here, we'll turn this over to Julie in just a moment. Loan forgiveness reductions, again, we're going to lose some of our loans if we do not keep people employed or if we cut their salaries too much. Like I just said on those other slides, we can fix that by restoring number of people and by restoring the salaries of the people that are there. Now jump up one more slide, please. Okay, here, this is interesting. Initially, there was a non-statutory rule that they built into the SBA regulations. This rule was beyond the scope of the statutes. And when the SBA added it, that was the 75% test. Congress came in and they said, well, we can live with the concept, but we're going to reduce that to 60%. And now they've announced that, let's say you can get, the statute would tell you you have to be right on 60%. I mean, like right on 60% for this to work. But if you're at 61 or 62 or 70, you're going to be just fine. Okay, let's look at these compensation limits. Now, what happens in terms of the employees? It's basically 100,000 of compensation over an 8-week period of time is going to come to about 15,000. That is the forgiveness you would get per employee maximum. That's the maximum you could ever get per employee. That's with 8 weeks of payroll. If we go up a little bit more, now we're on this, if you look at the next slide, we're on 24 weeks of payroll. And that substantially increases these compensation limitations. This is great. With 24 weeks, you're almost always going to meet these tests. So you're almost always going to meet these tests. If we look up one more slide, please, you're going to see that at 24 weeks, that number for your employees suddenly jumped to $46,000. Now, there's a little bit difference if you're an owner. It's more complicated than that. But for the rank and file workers, you're at $46,000. So that's going to help a lot of people get to the forgiveness they want. Now, one more slide. Most difficult thing that we have to cover. The law says you get that you're not going to pay tax on the forgiveness. Right? There's a statute that says no taxation on forgiveness. We know that. That is a given, plain vanilla given. However, the IRS came out with a notice and they said, well, that might be true, but we're not going to let you deduct the expenses that go into that. And the question that's going to come up very soon for some people is, what do we do when we do tax returns? Do we ignore what the IRS said in Notice 2020-32? Or do we file following the IRS's ruling and then file amended returns? Or better yet, I'm probably going to have my clients file protective claims to keep that statute open while this issue is litigated. Because unless Congress changes this to clarify it, the inability to deduct these expenses, according to the IRS, is almost certainly to be litigated. Okay, we have covered a lot of ground. Now it's time for us to learn more about the labor law aspects of this. We're going to turn this over to Julie.
Thanks, Bob. I appreciate that. So, as Diane mentioned, there were several phases of laws that came into place in March and made effective for the most part in April. Included in that batch were several sets of employment-related laws. If you expect that what we're about to talk about, which is specifically the Family Medical Leave Act and the Americans with Disabilities Act, does not apply to you because you don't have enough employees or your client doesn't have enough employees, I invite you to sit back because that may not be the case today. In addition to the FMLA and the ADA, we will talk about practical considerations for getting your workforce back to the workplace, and also your potential liability if someone is exposed to or gets COVID at your workplace. So, starting with the Family Medical Leave Act. Family Medical Leave is designed to allow an employee to take up to 12 weeks of unpaid leave for various health-related reasons. It could be adoption, it could be a serious medical illness. It does not need to be incapacitating illness. It could be just something that requires continued health care provider. And as well, it doesn't have to be continuous. It could be what we call intermittent benefits, meaning a day here, a week here, etc. Next, please. So 88% of all businesses employ less than 20 employees. Ordinarily, however, the FMLA only applies to businesses within 50 or more employees within a 75-mile radius. Next, please. So the FMLA does not apply to most small businesses as it was originally written. So, of course, why are we talking about this today? Because the FFCRA and other COVID amendments apply to 99% of all businesses. That's 88% of the workforce and 99% of all businesses. So let's talk a little bit about the distinction between the FMLA and the FFCRA and those new amendments. Next slide, please. Go ahead. So under the FMLA, as I mentioned, an employer must have 50 or more employees when it's a 75-mile radius. The employee also has to have worked for at least 12 months prior to the leave request, and the employee must have worked for at least 1,250 hours in the previous 12 months in order to be eligible. So part-time employees are usually not covered under FMLA. Under the FFCRA, however, it applies to any employer who employs under 500 employees. You'll also see that the employees can have worked for 30 days for full benefits, not 12 months. But frankly, you can also have, if an employee has only worked one day, they're going to have some benefits under the Act. And of course, there's no requirement for hourly rates. So, what does it cover? The first section is related to quarantine and illness types of coverage. If an employee is unable to work because the employee is subject to a quarantine order, either by a government or by a healthcare provider, there's coverage available. If that employee is unable to work because he is experiencing COVID symptoms and is seeking a diagnosis, coverage would be available. As well, if that employee cannot work because he is caring for an immediate family member who is subject to a quarantine order or is experiencing COVID symptoms, there's coverage available. There's also a unique situation here that was not a part of the FMLA, and it is childcare related coverage. So if an employee has a child who is under 18 years old and the school is either closed or made unavailable, or if the childcare, for instance, in the summertime, is made unavailable, then we also have coverage. And finally, there's a catch-all provision. Any employee who is experiencing substantially similar conditions as specified. What does this mean? We don't really know. It's a catch-all. The point is that if your employee comes close enough to one of these situations, he's probably going to be found to be within the substantially similar coverage. Next, please. So the benefits under the COVID amendments are divided into a couple of categories. For starters, let's talk about the sick leave. The employee who gets COVID or is under a quarantine order, is having symptoms and is waiting for a test, he is permitted up to 2 weeks of paid leave at his full rate of pay. If he is taking care of anyone else, it is paid at a 2/3 rate of pay. Note, I want to talk about this very quickly. A quarantine order is not the same thing as a stay-home order or a shelter-in-place order. So when you hear a quarantine order, that is generally when someone has been exposed or actually has symptoms. The individual is not only quarantined to his home, but also usually quarantined from the family members in the home. Also, note that if you already offer paid sick leave, this is not in lieu of, this is in addition to. So the effect of this is that if an individual gets COVID now and is sick and is out for 2 weeks, you owe him the full rate of pay. If in December he comes down with the flu, you also owe the payment of your sick pay benefits. Next, please. So these are the childcare related benefits. These are a little different. If an employee has worked less than 30 calendar days at your employment, then the employee is only entitled to 2 weeks of paid leave at 2/3 of the rate of pay for childcare related issues. Again, those childcare related issues are a child under 18 whose school or childcare is unavailable due to COVID related reasons. If the employee has been working for more than 30 days, then the employee is entitled to a total of 12 weeks of benefits. The first 2 weeks are unpaid, but the additional 10 weeks of paid leave is at a rate of 2/3 pay. Now, a couple of things that are important there. The employee has to make a diligent effort to secure childcare. So for instance, if we're talking about his favorite camp is not available, if there's another camp that's available, then you must get it. Or if there is a parent or a grandparent or aunt or uncle or some other childcare available, then you must make the diligent effort to obtain it. Now, I do want to make this note. In the previous slide, when we were talking about sick pay and COVID illness benefits, you were not allowed to substitute the COVID pay for your sick pay and vice versa. Here, if the employee who is working 30 days or more needs the 2 weeks of unpaid leave, which is going to be first, you're going to make the unpaid leave be taken first, and then the additional 10 weeks of paid leave thereafter. If that person has any type of accrued vacation benefits, he may, at his election, opt to use those benefits in lieu of the unpaid leave. But when you're dealing with sick leave, you can't require that to be the case. Next, please. So when will this end? These acts have a sunset provision where the acts will sunset at December 31, 2020, if it is not extended. Now, some of the things that are going to probably go into whether or not these benefits get extended are whether or not we have a vaccine in place, or whether it will be readily available if it's at least, on the horizon. Also, another uptick in the fall or the winter. I know right now we're experiencing an uptick in COVID-related illnesses, and I expect a greater uptick, frankly, in the fall and possibly winter. If we are still struggling with that, if we see a decrease in available ventilators, we may wind up with additional benefits on this one. We just don't know. We're just going to have to wait and see on that one. Now that we've talked about all the bad parts, let's talk about some of the employer protections. So the first thing is a second uptick, meaning a second wave of COVID-related illnesses, does not mean a second set of benefits. So if an individual has gotten sick the first time, or has taken leave to care for someone who had symptoms or had symptoms but eventually was not tested as positive, he doesn't get another set of 2 weeks of paid leave in the fall. Also, these benefits are not in addition to the 12 weeks of ordinary unpaid leave of FMLA. The goal is to provide an expansion of what constitutes leave under the FMLA. They're not in addition to. The only time that you're going to see something beyond the ordinary 12 weeks is if you have 2 weeks used of sick leave, and then an individual opts to take up to 12 weeks of the childcare leave. That's the only time that you're going to get more than your average benefits under FMLA for a temporal period. And finally, and this is really important, if your employee is able to telework, meaning working at home or come up with an alternative schedule, then the employee cannot elect to take leave. Next, please. So also a little bit of good news here. The paid leave for your employee quarantine is capped at $511 a day or $5,110 in the aggregate. So if your employee earns an average of $800 a day, he's still only going to get $511 a day, despite the language that states that he's allowed full pay. And then, of course, the aggregate is the up to 2 weeks of leave. All other leave, when we're talking about caring for other individuals who may be sick, or childcare leave, is capped at $200 a day and $10,000 in the aggregate. So again, if your employee earns $800 a day, he's only going to get $200 a day for the alternative leave, and $10,000, meaning up to the 10 weeks of the paid leave in that aggregate. Now, that is not going to include what you pay him in paid leave time. It's strictly what we're talking about with respect to the COVID requirements. Tax credits are available. You do have an immediate dollar-for-dollar tax offset against payroll taxes. And also it's refundable. If you have credits that exceed your tax liability, you can have those refunds paid to you. There is also a provision that allows you to obtain advance payment on employer credits if you are in need. And then finally, we have an exemption that is available through the DOL for undue hardships. Now, this is, as you can imagine, it's going to be frankly financial related or operational related, which is to say, if the business expenses and financial obligations exceed the available business revenues, and then in all likelihood, what you're going to have is an availability for an undue hardship. Same thing with a leave or sets of leave of your employees that cause some sort of hardship, either through labor force or through specific individuals who, because of their knowledge, expertise, education, etc., make running the business, even at a minimum capacity, impossible or incredibly difficult. If you need that exemption, I invite you to go to the Department of Labor's website. They're very helpful. You can search for exemption waiver and you should be able to find what you need. All right, let's move on. So another question that's come up in my field is COVID a disability under the Americans with Disabilities Act? Well, that's takes a few questions to get to that answer. Next slide, please. First, I want to let you know, Americans with Disabilities Act only applies to private employers with 15 or more employees. Well, most of you may not have 15 or more employees, but this is the deal. There's something called the Rehabilitation Act. And even though the Rehabilitation Act came in front of the Americans with Disabilities Act, it's essentially an extension of the ADA. All the protections are still in place, but the Rehabilitation Act extends it to any individual who, or I'm sorry, any employer who is a federal contractor or a subcontractor or a private employer who receives any form of federal assistance. So we've just been listening to Bob talk about the PPP. Is that federal assistance that would put you under the RA or the ADA? That answer is actually no. However, if you have gotten an economic injury disaster loan or some of the other loans that are available through the federal programs, you are covered under these events. So previously, you may not have had to worry about the ADA constraints. Now you do. Next slide, please. So what did the ADA and the Rehabilitation Act do is prevent discrimination against any disabled individuals who can perform the essential functions of their job with or without reasonable accommodations. Now you'll note I have reasonable accommodations in both bold and italics, which means it must be important, and it is, but we're not going to talk about that right now. We're going to talk about disability right now, because disability is very broad. Disability is what you believe it is, which is a physical or mental impairment that substantially limits one or more major life activities. But it also includes a person who may have had a history of the impairment. For instance, he has a condition that required various apparatus to work, to see, etc., but it tends to come and go. That person is covered even when he does not have the present impairment. And finally, this is the broadest section, and this is the one that tends to befuddle most. A person who is perceived by others as having an impairment is also covered. And I'm going to give you a quick example. If an individual who has hepatitis C works in close quarters, the other employees don't want to work with that individual because they think that he may be contagious, that is perceived as having an impairment. And so we have COVID. COVID is contagious. Does that require an impairment? Next slide, please. Next. So the first question is whether it's transitory and minor. If it is, it's not a disability under the Act. COVID is generally transitory and minor, except for when you go to those who are in hospitals, on ventilators, etc. Next, please. If the disability is sufficiently severe, then you might have a disability, but he's also got to perform the functions of his job with or without accommodation. And that's not likely the case. So COVID, the illness itself, is probably not going to be a disability. However, let's go to the next slide. Lasting effects may be. All of these things that I've listed on this screen will be a disability under the Act under the right circumstances. So next slide. Why does this matter? Because of the reasonable accommodation requirement. And all of this revolves around the problem that we are now telemarketing. Employees are now like to work from home, and the courts used to be pretty deferential about whether we would consider that a reasonable accommodation. They are probably not going to be so differential now because we've gone through this COVID virus. We have all been working from home, and we're still kind of making it. So we do have that consideration going forward. I'm running short on time, so I want to blow through some of this really fast. If you have an individual who wants to continue to work from home for whatever reason, they like working from home, they are afraid of being exposed, they have comorbidities, all of these are good reasons, but they're not protected reasons. Next screen. If you have this issue and you need to get your employee back into the workplace, address the concerns. Ask yourself, are you symptom monitoring? Are you requiring masks? Are you limiting the number of people? Are you enforcing your own rules if you have them? Next, please. So have a plan. Make sure it's government compliant. Make sure it's CDC compliant. Put it in writing and disseminate it. Do not stick it in a drawer once you've written it up. Next. So once you have a plan, if you have habitual offenders, you need to discipline them. And if discipline does not work, then you need to terminate them. Likewise, if you've got a plan and you're enforcing your own rules, the people who are not returning to work can also be disciplined and, if necessary, terminated. Okay, medical screening is allowed. I'll tell you this, don't antibody test as a requirement. It's not related to business necessity. And that's going to be the hallmark of what you can do when you have your employees to come back. Next. If you are recording these symptoms or not symptoms, keep it in a record under lock and key, separate and apart from the regular employment files. And frankly, I don't recommend that you record them anyway. And as well, obtain permission from any of your employees if they do have COVID or are exhibiting symptoms before you identify that employee to your others. And just make sure that you are cognizant of those privacy concerns. Next. Last but not least, all state laws are going to determine whether or not you have tort immunity if someone is exposed. Louisiana came out with legislation last month that was signed into law. Louisiana is not in front of the curve on any matter, so I would imagine that your state has already done so as well. I would expect that you're going to have laws relative to your employee exposure to follow your workers' comp laws, which is they go through workers' comp unless they can prove that the exposure was actual and intentional. With respect to third-party claims, invitees, Louisiana's law is as long as you are substantially complying with some COVID procedures that are established by any governmental agency, doesn't matter which one, then you won't have tort liability. And I do expect that that's going to be the same for your state, but certainly check with a local attorney in your area who can help you with that. I have run long, and my apologies for that, but with that, I'm going to turn it back over to Keith.
Thank you, Julie, and thanks everyone for participating today. We do have a few questions. Julie, what specific steps can you take to have empathy for the situation but still hold people accountable?
Well, I think it's that interactive communication process. Let them know you've got a plan in place, but tell them or ask them questions. What concerns you? You may find out that you think you've got a plan in place, but the other side of the office isn't really complying. Have that dialogue with them. Explain to them what you're doing, how you want to move forward. ask them what you can do to assist in getting them more comfortable and back. But keep in mind, as long as you have a plan, it's compliant with government or CDC guidelines, then you have a right to expect your employee to come back to work.
Thank you. And this is for Bob. Bob, I leased staff from another advisor instead of hiring them directly. Coincidentally, I had my staff hired by this other advisor on 3/1, so I'm concerned it will look like I laid them off. What documentation do I need to validate myself for loan forgiveness?
I'm really not sure what you should do. If you email me privately, I can put you in touch with somebody that might be able to help you. But I don't know the right course of action there.
Okay, well, let's try this one. How do I make sure that I have the proper information and documentation ready for the forgiveness processing?
I think every entry on that form has to be backed up. So you don't have to go search for it, that you feel comfortable with it. I would have all those entries reviewed by the accountant that does your income tax returns, just to make sure they're going to sync with the income tax returns. And then if you're over 2 million, again, like I said earlier, line up that litigation attorney. If the government decides to, they will audit you. If they decide to really take away your loan and deny you forgiveness because of the necessity issue, you want to be in a position to reply to that and have your basic argument put together on the front end.
Julie, my assistant works 40 hours a month. How are we affected?
Well, you still have your obligations under the COVID leave amendments. However, the pay for your assistant is going to be only the average of your 40 hours per month. So if it's 10 a week, that is what the full rate of pay is.
Okay, great. Let me ask you a quick follow-up to that. I'm a small employer. It's really tough when the 1 or 2 key employees that we need to run the business are on leave, in quotes, due to valid, in quotes, reasons. Hell, it's very hard to keep functioning.
It is. So we have a couple of options. First, you need to take a look at making sure that the leave is valid, and it sounds like you might question it. So if it's for medical related leave, you've only got 2 weeks. If it's childcare related leave, ask if they've got alternative care. Third, in any circumstance, can they continue to work from home? Keep in mind, if they can continue to work from home, they're not entitled to leave. You may require some flexibility on your part, but you can at least get them working and back in the workforce. Finally, if it's too much, then you may want to consider applying for your exemption with the Department of Labor.
All right, last question, and we'll try to get these other ones answered for you that are in the queue. Bob, any changes or further guidance to EIDL expected?
Well, there might be some fine tuning, but that program actually is working fairly well.
Okay, great. And I want to thank everyone today for signing in and joining our program. Some great questions, and also particularly want to thank our 3 speakers, Diane, Julie, and Bob from NAIFA and from the NAIFA community for giving your time to prepare and to attend this meeting. And with that, I'll turn it back over to NAIFA staff. And thanks again, everyone, for attending.
Thanks, Keith. This concludes the webinar. Have a great day.